Today is your deposition. A deposition is a question and answer session. The lawyer for the negligent party is going to ask you questions on a multitude of topics ranging from where you live, your background, your professional experiences, your educational experiences, the accident itself, your injuries, your pre-existing conditions. I have 3 rules, and if you follow these 3 rules, you'll do just fine, all right? Don't lie, don't guess, don't talk a lot. And if you follow those 3 rules, you'll be fine. The objective is to maintain your credibility, all right? And we do that by not lying. We do that by not guessing. We do that by not talking a lot. I don't think you're gonna lie about anything, but I'd say that because some people just can't get out of their own way. The guessing is dangerous, especially in a car accident, because the other side may ask questions about the distance between 2 points or the speed of the vehicles, or the positions of the vehicles involved. If you don't know the answer, it's more credible to say I don't know, okay? And you shouldn't be bullied into giving an answer. The other lawyer has a job to do. They're going to ask questions, and their job is to try to gain an understanding and clarity about what happened. But just because the lawyer asks you the same question but worded differently doesn't mean that the 5th time they ask it, you should have an answer, okay? Right. And I'll tell you, it's incredibly powerful when a witness refuses to guess. It actually strikes everyone in the room as, wow, this person is not going to subject their credibility to a guess. If you don't know, you say it. And it's a perfectly valid response that we use in everyday language. So you say it. Now, some people take it too literally and they say I don't know to everything, and then they just look like an asshole. But it appears as if they're trying to be an obstructionist, okay? So you don't want to do that. But also, dates of appointment. No one's expecting you to remember all of your medical appointments. We do want you to be knowledgeable about your pre-existing medical conditions. The insurance companies have run very in-depth backgrounds on you both, and they know. So you just own those things and you talk about them. And then, like I said, don't talk a lot. These depositions will go faster if you keep your answers short and succinct. And they also provide more clarity. You have to remember that during the deposition, a court reporter will be taking down everything that is said, the questions and the answers. These transcripts are so much easier to read when there's a short question followed by a short answer. And by easy to read, I don't mean like time-wise. I mean that there's no ambiguity, right? If you as the witness, you give these long narrative responses, that's where ambiguity grows, and we don't want that. So if you follow those 3 rules, you'll be all set. I will give you a license to talk and give some meaningful responses when it comes to your injuries and the limitations and disabilities that arose from those injuries. We're going to put a value on your case, not just based on the physical injury, but how that injury affected you. And so this is your opportunity to grow that value by giving them insight into how that injury affected your life, all right?